Welcome to the Beef Roundtable. I'm Dr. Ron Lemonade, your Beef Extension Specialist at Purdue University in West Lafayette, Indiana. And I will be working with my co-host, Burt Rutherford.
And I'm Burt Rutherford, Senior Editor of Beef Magazine. I'm based in Amarillo, Texas. Each month on the Beef Roundtable, we discuss timely topics that impact the beef industry.
The Beef Roundtable is recorded live and edited to fit the time constraints of the program. The programs are available at the Beef Magazine website, iTunes, YouTube.com, as well as www.beefroundtable.com. The
U.S. Environmental Protection Agency and the U.S. Army Corps of Engineers published on June 28, 2015 in the Federal Register the final rule that redefines the waters of the United States as it relates to their jurisdiction under the Clean Water Act. This rule goes into effect on August 28, 2015, and will impact farmers and ranchers all across the U.S.
According to the EPA, the rule does not create new permitting requirements, and all exemptions and exclusions that previously existed under the Clean Water Act have stayed the same. However, the final rule does make significant changes in the definitions of ditches, wetlands, streams, tributaries, and other water features that are subject to federal regulation under the Clean Water Act.
We have two guests with us today to discuss the impact of the WOTUS rule on food and fiber production in the United States. Our first guest is Mr. Bob Stallman, President of the American Farm Bureau Federation, the nation's largest and most influential general farm organization. He joins us today from the American Farm Bureau headquarters in Washington, D.C.
Our second guest is Mr. Steve Fogelsong, who is the patriarch of a family-owned and operated Black Gold Ranch and feedlot, a diversified livestock grazing and cropping operation located near the central Illinois town of Astoria and the ranch in southwest Georgia. Steve is a past president of the National Cattlemen's Beef Association.
Bob, the American Farm Bureau has been an industry leader in evaluating the impact of the EPA and the Army Corps of Engineers' efforts to redefine waters of the U.S. under the Clean Water Act. Would you please recap for us the work that the Farm Bureau has done over the past several years on this issue?
Well, I'd be glad to, and I certainly appreciate the opportunity to be on the program. American Farm Bureau Federation has had a long history with regard to what is the scope of federal authority that's allowed under the Clean Water Act, up to and including involvement in 2 Supreme Court cases. Just a long history, because we have seen repeated iterations of the use of the Clean Water Act to, frankly, restrict what private landowners, farmers, and ranchers can do with their property. When we first got wind of this effort to put out a new Waters of the U.S. rule, which ostensibly was to clarify the EPA's authority and supposedly have it be consistent with the last Supreme Court ruling, we knew from experience that we had to pay really close attention to what they were doing. So we waited till we got the proposed rule published, and then we went through it with a fine-tooth comb. Very intense legal and policy analysis, trying to figure out what it would mean on the ground for farmers and ranchers. And our conclusion was that it was particularly egregious to farmers and ranchers, and frankly any property owner and most other industries, because the definitions were so broad-reaching and vague about what would constitute a water of the U.S. that we pretty much deemed it was a mechanism, a regulatory mechanism, by which the EPA could effectively control land use. So that was the rule as proposed. We initiated a campaign because we thought it was very important to get information out about the potential impact of this rule, called Ditch the Rule. It was a social media, a very public-driven campaign. It was very well received, and people paid a lot of attention to it. Part of that campaign was to generate comments on the rule as part of the rulemaking process, to talk about some of the problems that existed in it. And we felt like we were really successful at the educational and sort of the advocacy efforts surrounding the proposed rule. We were hoping that the comments and the activity generated around that rule would actually cause EPA to, take seriously some of the concerns that we had in agriculture about what the impact was going to be. But instead, they sort of started trying to counter what we were trying to do individually, and we may talk about that later, but it bordered on advocacy as far as we were concerned. And when the comment period was finished, then we knew we had to wait till the final rule was proposed and see if they had actually taken into account the comments that were received. And we were hopeful they were, but we weren't expecting them to, and our expectations were met. They did not. In fact, they actually made the rule worse than what it was initially. And this was after thousands and thousands of substantive comments about the negative aspects of this rule and problems that existed with the definitions. Once the final rule was out, then the process needed to begin to do something about it because it was so egregious that it was going to be harmful to farmers and ranchers. And we've started working in the Congress to try to come up with a legislative solution, including either scrapping this rule and going back from square one and starting over, or at a minimum remove funding for any implementation of the rule. Given the difficulties in getting anything passed in the United States Congress, we also have moved into the courts, filing litigation to challenge the rule based on a whole bunch of the problems that existed in it. So that's been our history to date, and we're still working very hard to see if we can fix this.
Bob, the EPA characterizes waters of the United States as merely an adjustment of the wording of the Clean Water Act. Is this merely an adjustment of the terms, or are we witnessing a regulatory overreach that goes beyond congressional intent?
Well, I can't quote you Webster's definition of adjustment, but the common understanding of that word as I know it, this goes far, far beyond any adjustment. This is an attempt to broaden the scope of regulation far beyond what Congress ever intended and far beyond what the Supreme Court has said that the EPA has in terms of scope of authority under the Clean Water Act. And that's been the advocacy part of what EPA has done. They've couched this in terms of, oh, we're just trying to honor the Supreme Court decisions. We're just trying to put a few refinements around it and make some adjustments to comply. But when you look at the far-reaching impact of the way the definitions are proposed, and it all boils down to water. All of us in agriculture know how important water is for us when we produce our crops and our livestock. And whether it's just when it rains or maybe on a more regular basis, we have water running, by our fields, across our fields, pastures. Water runs downhill. And so every operation is impacted by water, even those sometimes out west that don't get very much rain or have very infrequent rainfall events. And the definitions are designed such that any place water runs or frankly moves downhill, that EPA then, or puddles I might add, then EPA under these definitions is going to, at least the way we see it, have the ability to say, well, that's the waters of the U.S., and therefore you need a permit to conduct all of the activities that you've been, frankly, conducting on that farm or ranch for years, and now all of a sudden you need to go to EPA to get a permit to continue doing them. So, yeah, this goes way beyond any adjustment as I would define it.
Before a rule becomes final, there is testimony given at congressional committee hearings. Steve, this past spring you were invited to testify at one of these congressional hearings. Can you provide us with a recap of how this new rule will affect farms and ranches across the country, and maybe even give us some examples?
As a livestock producer, I can tell you that after reading this rule, it has the potential to impact virtually every aspect, of my operation and others like it by regulating potentially every tributary, stream, pond, tank, dry stream bed, and we've got a zillion of them here in our place. What's worse on that deal is the ambiguity of the proposed rule that makes it difficult, if not impossible, to determine just how much my farm will be affected, and the ambiguity in the tributary definition that places all landowners in a position of uncertainty and inequity. I had a meeting with the EPA in D.C., And we argued about all of those definitions for an entire day, and I don't think we came out of there with any kind of clarity. Ron, my land is reclaimed strip mine ground, and we've used hogs and cattle and the manure they produce to get this land back into a state of production. I've got seasonal streams that run all through the pastures and fields, as well as this innumerable ponds, lakes, and ditches. If those features all become jurisdictional under the WOTUS rule, the question is, would cattle that are hanging out in or near that water, and everything goes along with that, constitute a discharge that I would need a permit for? It may sound silly, but you know, there's lots of those kinds of structures all across the country. You know, out in Oklahoma, they call them tanks. You know, you've dug those out, you know, specifically for cattle water. Cattle stand in there, and I talked to those folks there in D.C. about that when I testified. I've got a creek running through my place called Otter Creek. It's questionable, virtually impossible, that Otter Creek would have been considered a federal water before, because through the course of the summer, you know, there's no water that runs in parts of it. Now, it gets bigger when you get on down towards the Illinois River, and Otter Creek obviously would be, but it's not gonna, you're not going to take your boat up in there very far. But now it's most likely going to be deemed a tributary, and the headwaters of that tributary are here on our place. Now it'd be considered a WOTUS. Also, all of the little ponds and water holes and those channels that hook those together that wind up in there, now that whole thing. So from my perspective, reading this rule, virtually all of my property will be considered waters of the United States. And I'm going to need a 404 or a 402 permit to conduct everyday activities in or near that water in order to try to be anywhere close to being in compliance, let alone the cost and the time-consuming part of paperwork. I don't know about you, but paperwork is not my long suit, and I certainly don't need to spend a lot of time filling it out.
Before the rule becomes final, there's a public comment period that allows interested citizens, organizations, and businesses to voice their support or opposition. The comment period for the WOTUS rule ended several months ago. Steve, was there ever any outreach to farmers and ranchers for their input on the rule changes?
Yeah, Bert, I know that EPA has talked about the fact that they went out and met with, 400 or so outreach meetings of stakeholders. I wasn't there. I honestly don't know anybody, that was at those meetings. And all I can say about that, if that indeed is true, it's certainly not evident in the final rule. There are major issues that will affect farmers and ranchers all across the entire country.
Do you think the rule would look any different if farmers and ranchers who do produce food and fiber were consulted on it?
Well, I would certainly like to think so. When I testified there in D.C. this spring, there's a gentleman from Mississippi, another producer that was sitting there, and we offered to sit down with the EPA, and you throw us in the room with some regulators, and we could come up with some ideas where you actually had people that had a vested interest, in this process to put together rules that could actually be implemented. If we did that, I don't think we'd be sitting where we are today if we'd actually had an active role in that.
According to the New York Times, and I'm quoting here, the EPA sponsored a drive on Facebook and Twitter to promote its proposed clean water rule in conjunction with the Sierra Club. At the same time, a group Organizing for Action, a grassroots group with deep ties to Mr. Obama, was also pushing the rule. They urged the public to flood the agency with positive comments to counter opposition from farming and industry groups. The results were then offered as proof that the proposal was popular. End quote. Bob, from the Farm Bureau's perspective, is it legal or even ethical for a department within the government to use this type of approach in the rulemaking process?
Well, that's sort of an easy question to answer from our perspective. We believe that activity was unethical and inappropriate, and frankly unlawful as well. Public agencies are not allowed to use taxpayer dollars to advocate for policy or laws. And we had our we put out our Ditch the Rule campaign, which once again got a lot of attention. And so EPA came out with a counter campaign called Ditch the Myth. Now, if that's not advocacy, I don't know what is, but American Farm Bureau Federation is an advocacy organization. EPA is not. It's a government agency, and they do not have the freedom to advocate on behalf of any policy or rule. So we believe it was unlawful. We believe the New York Times article was right on target.
Bob, in June of 2014, you testified in a congressional committee hearing and referred to the Clean Water Act and the Supreme Court ruling in the Rapinos case. In the plurality opinion of 4 Supreme Court justices, written by Justice Scalia, he wrote, and I quote, "The Act's use of the traditional phrase navigable waters further confirms that the Clean Water Act confers jurisdiction only over relatively permanent bodies of water," end quote. Justice Scalia also wrote in a second case heard by the Supreme Court, and I quote, "The waters of the United States hardly qualifies as the clear and manifest statement from Congress needed to authorize intrusion into such areas of traditional state authority as land use regulation, and to authorize federal action that stretches the limits of Congress's commerce power," end quote. Bob, with reference to these 2 Supreme Court cases and the past interpretation of the term quote-unquote navigable waters and the term quote-unquote significant nexus with navigable waters of the United States, as well as new definitions for tributaries, streams, ponds, and wetlands, how is this new rule going to affect America's farmers and ranchers' ability to produce food in the future?
Well, I believe it's going to have an extremely dampening effect on our ability to produce food, fiber, and fuel in this country, pun intended. When you have a farmer or a rancher under the obligation by regulation to have to go to a federal agency to get a permit to plow, plant, put out chemicals, fertilizer, build fences, graze livestock, you are in effect giving the federal government control over those activities. Worse yet, the law and the regulation around the Clean Water Act is such that it allows private entities to file suit against individuals who may be conducting these activities if they don't believe that the EPA is sufficiently regulating these activities. And since the resources of the EPA in terms of compliance and enforcement are somewhat limited, they don't have an infinite budget, you know, these activist groups, if they don't like a particular farming operation or, you know, whatever the case may be, they can go out and file a citizen suit based on the activities of that farmer or rancher and challenge the EPA for lack of enforcement of the law. Now, that is a burden that's a heck of a lot worse, frankly, than having to deal with the weather and markets and maybe policies of foreign governments related to trade. We have to deal with those in agriculture. But we should not have to deal with the very uncertain nature of this particular regulation, where I can read that rule and look at my farm in Texas, and I can't tell you what a water of the U.S. is based on that rule, because the definitions are not such that I can look at my land and take those definitions and know where a water of the U.S. is. So the only way you can find out is to request a jurisdictional determination from the Corps of Engineers, and then find out on your property what is officially considered a water of the U.S. And then at that point, if you conduct your normal farming and ranching activities, even though EPA said those are exempt, they're not. If you conduct activities that move dirt or put out spray chemicals over those waters of the U.S. as defined, even if there's no water there and even if it's dry land, then if you don't have that permit, you're subject to some pretty extreme daily fines. And that's just not a regimen that U.S. agriculture can operate under and be successful. And unfortunately, too many farmers and ranchers are going to find out just how bad this is after the rule is implemented.
Steve, there's a lot that's been made of the rule's zero flow ditch exemption. Can you elaborate on this part of the rule and explain how that might impact your operation?
Yeah, this is pretty goofy. The EPA's got an exemption for ditches in the final WOTUS rule. And that'd be a great thing, but the problem is with the rule, it also has a lot of exemptions to the ditch exemption. So it's exemptions to the exemptions. For example, if your ditch is a relocated tributary, if you've moved a creek, or you build a tributary, you know, to drain off a piece of ground, at any point in the entire history of the land, then that's out. You can't have the exemption. The problem here is you can't just go out on a piece of property, and my property is a huge example of this, on your land and determine that this stuff, you need to have a complete historical record, you know, of what's happened on your land long before you owned it. These records don't just exist for most places. I got a place in Georgia that I just bought. I have no idea what was done and, you know, what has been done. There's ditches there. Have they been cleaned? Have they been straightened? There's no way for me to do that because it's probably several landowners deep back in exactly what it is, but we're supposed to know all of that.
Steve, given that this new rule will be implemented on August 28th, 2015, do you anticipate any new permitting or paperwork on your from your operation?
That's 3 weeks from today, you know. I can't imagine. There's nobody that's prepared for that. Like I shared with you earlier, there's lots of water features, both wet and dry, on my land that we'll need to take a closer look at. And needless to say, I'm afraid we'll be working with government officials and attorneys to sort out what we're needing to do to try to get anywhere close to meeting that definition of the Clean Water Act that the WOTUS has put into place.
So you kind of think that litigation is going to be the way this thing is going to get resolved?
Well, there's a number of ways that could be resolved. You know, there's some legislation that's out there right now, and pending legislation. That's the short fix. The quick fix and the most definite fix is if we could step into that and pull this thing, and then back up, get some producers in the room with the regulators of the EPA. You know, and then if that doesn't work, you know, there's this whole slew of lawsuits that have been filed by lots of associations, National Cattlemen's Beef Association, state associations, lots and lots of outfits are together on some lawsuits. Problem with that is I'm not a real big litigator. I don't like that. You know, that's not a solution to anything. All that is an invitation for yet another argument. But if you assume that rule becomes in effect, my message out there is that we're all going to have to take a good, long, hard look and find out whether we're in compliance or out, or we're going to find ourselves in a situation with litigation, you know, with the EPA and others as we go down this path.
The final WOTUS rule states that if a water does not fall within certain jurisdictional categories, it can still be deemed a WOTUS through a case-specific analysis. Bob, from the Farm Bureau's perspective, do you think the new EPA definitions and verbiage of what constitutes, quote, waters of the U.S. provide clarity, or do they just add confusion that allows unintended consequences?
Well, compared to where we are today, I actually think it involves confusion, a lot more confusion. This rule lacks any type of clarity that allows a farmer or rancher, I think, to look at their land and try to figure out what they should do and what they should not do. And even worse than that, the EPA or the Corps won't really even give you examples. Every time you ask them about, well, is it okay to build a stock pond? Or what happens if you build a fence across this feature? Is that going to require a permit? And the answer you uniformly get is, well, we can't tell you. So what kind of uncertainty does that create for farmers and ranchers? And, you know, I would contend it creates a degree of uncertainty that puts the businesses of farming and ranching at risk. And I, you know, hope that we find a resolution ultimately that prevents that uncertainty from existing and allows us in agriculture to do what we do best, and that's continue to produce food, fiber, and fuel, and frankly, we do it in an environmentally responsible way.
Well, I think it's interesting that several times during this program, but also in the media coverage, we talk about this WOTUS rule being a combination of EPA and Army Corps of Engineers. But there's been several pieces of communication that have been released recently that were written by the Army Corps of Engineers to EPA regarding inconsistency as well as flawed methodology, interpretation, and conclusions drawn in the economic analysis and technical support document that EPA says justifies the rule. The documents indicate that the Army Corps of Engineers has requested that their name be removed from the final rule as an author, co-author, or a substantive contributor. So Bob, what is Farm Bureau's reactions to these recent revelations, and what is Farm Bureau's next step?
Well, first, we're thankful that these memos and emails, which were meant for internal use only, have seen the light of day. You know, this is one of those examples where transparency in government is very important. These emails and communications from the Corps of Engineers, which incidentally is the entity responsible for the jurisdictional determinations, I think are very important to prove the case we've been trying to make all along about, first, that the entire rulemaking process was flawed and EPA did not take into account either the science or the economics involved in the effects of the rule as they proposed it, and the Corps memos actually certainly substantiate that. And then you get some of the memos that in essence say that the Corps doesn't know how they're going to enforce this. They don't know how they're going to make those determinations because the language isn't clear enough to do so. And you know, seeing all this comes to light, I think does a couple of things. One, it makes us feel good because it justifies what we've been saying all along. But then number two, it gives us some leverage, I think, with members of Congress to say, you know, guys, here's the agency that was supposedly involved in putting this rule out and supposedly working with EPA, pointing out how bad it is, how it won't work. And frankly, there was one communication that indicated it wouldn't withstand litigation. So that's another reason why Congress needs to go back and fix this. And so having those come out when they did, I think is critical to our whole effort to figure out what we can to stop the implementation of this specific rule. And then let's figure out a way to move forward with some rules that do provide clarity, but build them around the actual Supreme Court rulings, particularly the Rapanos case, so that we do have clarity, but at the same time, it doesn't expand the reach of EPA over, frankly, all of the land of this country on which water may run.
The new rule has prompted significant debate in Congress. Several pieces of legislation have been introduced that could either kill the rule outright or through appropriations measures halt the implementation of the rule. The likelihood of either of these two approaches altering the course of the final rule remains in question. Steve, assuming that the rule takes effect, what's your take-home message for ranchers and farmers who are going to have to come into compliance with the new rule?
Well, I'm afraid they're going to have to be real friendly with their attorney because they're liable to wind up in court with them. I would have a hard look at, you know, what you're try to understand, and that's going to be the real challenge here because we're not clear on what those definitions are. We're going to have to make a decision and a determination of whether we have those wetlands available. But it's so hard when we don't know exactly what's going to be included as a wetland. But now I think we're going to wind up with lots and lots of people with litigation, or we're going to wind up looking for a 404 or a 402 permit for virtually anything that we do out there. You know, if you got cows in a pond, is that a violation? You know, I got lots of ponds and cows on a hot day like today, they're out there hanging out, you know. And are you going to build a fence around that pond or through that pond? Any of those kinds of activities that are going to potentially, on any land that's got water running off, it's going to wind up having to have a permit. It looks to me like it's going to be a busy day at the permit office.
All right, thanks, Steve. Well, that about wraps up this edition of the Beef Roundtable.
We'd like to thank our guest, Mr. Bob Stallman, President of the American Farm Bureau Federation, and Mr. Steve Fogelsong, past President of the National Cattlemen's Beef Association and owner-operator of Black Gold Ranch and Feedlot, for being our guests.
The Beef Roundtable is a joint production of Beef Magazine and the Purdue University Department of Animal Sciences. The Beef Roundtable is available on the Beef Magazine website, as well as iTunes, our YouTube page, and at www.beefroundtable.com. We'd really like to hear your comments about what you've seen, and we'd like, if you have any suggestions on future topics, we'd like to hear those as well. And you can submit those at the comments section at the bottom of the website.
Please join us again next month when our Beef Roundtable discussion topic will be common sense beef cattle marketing. It should be a great discussion. Until next time, Bert and I wish you a safe and rewarding month.